cases on our afternoon docket, and this is Division 4, the Court of Appeals. I'm Michael Berger. To my right is Judge Janice Davidson. To my left is Judge Robert Kapelke. Are the lawyers ready for the 1:30 case, which is People versus Drummond?
Yes, sir. Yes, sir.
Thank you. And then at 2 o'clock, we have Old Dominion Freight Line versus Sanchez and ICAO. Are counsel ready in that case? Thank you. As you probably know, all of our oral arguments are broadcast live and archived, so if you don't want something you say to be out there forever, don't say it, because it will never go away. I don't think these are the type of cases that implicate either the identity of children, but still, be careful what you say. Each side has 15 minutes. Appellants can reserve whatever amount of time you wish for rebuttal, but it's up to you. You have to manage your own time. We won't keep that for you. If anyone has any electronic devices, please turn them off. We're told that just silencing them doesn't do the job. I don't know why, but please turn them off so it doesn't interrupt the argument. Do any of the lawyers have any questions about our oral argument procedures? Okay. I don't hear any, so let's proceed to hear argument in People versus Drummond.
Good afternoon. May it please the court, my name is Kamala Maktabi, attorney registration 47694, and I represent Ms. Drummond, the defendant appellant. This case has a number of issues, but due to the limited time available, I'll focus on issue 4, whether numerous instances of prosecutorial misconduct deprived Ms. Drummond of her right to due process in a fair trial. As this argument was set by the Attorney General, I also intend to reserve some of my time for rebuttal.
Could you either speak into the microphone or louder or both? I'm pretty sure the people back there can't hear you.
Okay. As this argument was set by the Attorney General's office, I also intend to reserve some of my time for rebuttal. Our Supreme Court has said that improper prosecutorial statements can evoke strong reactions in jurors and take them down the path towards a conviction where the evidence does not necessarily lead. That's what happened here. The prosecutor crafted arguments fraught with improper and misleading statements that led jurors to convict Ms. Drummond despite weak evidence of guilt. The misconduct was pervasive and flagrant and requires reversal even under plain error review. There's a variety of misconduct here that's detailed in the briefing, but I'll highlight the most glaring and prejudicial.
Which is the worst?
The worst is where the prosecutor repeatedly in closing argument and again in rebuttal argument repeatedly told the jury that the law prohibited them from considering portions of the evidence that was favorable to Ms. Drummond because such evidence was mitigation. The prosecution defined mitigation as meaning a lot of factors that make this not so bad. In order to make this argument, the prosecutor first implied that the defense theory was an appeal for jury nullification based on sympathy and bias for Ms. Drummond. But that wasn't the defense. Defense counsel consistently argued, she stated in opening statement and again in closing argument, that Ms. Drummond was not guilty of criminal mischief because she didn't have the requisite culpable mental state as required under the statute. In other words, she didn't knowingly damage MM's car, the victim's car. Nonetheless, in closing argument and rebuttal closing, the prosecutor first implied to the jury that the defense was seeking jury nullification, and then it told the jury that the law and the judge required them to disregard evidence favorable to Ms. Drummond's defense that she didn't have this culpable mental state.
What evidence was that, do you think, that was relevant to her defense that she didn't have the culpable mental state?
The evidence was basically the circumstances surrounding the accident. So defense counsel there was no direct testimony on what Ms. Drummond's mental state was at the time of the accident. Both sides urged the jury to consider the circumstances surrounding the assault to infer what her mental state might be. Defense counsel argued that it was very relevant for the jury to consider the fact that Ms. Drummond had been beaten by the victim immediately before this car accident, that she had been, basically, the victim had punched her in the face with a closed fist. Ms. Drummond was bleeding from her face, she was crying, she was upset, she was trying to leave this apartment complex, and she was restrained, as she was like making her exit, she was restrained by this group of individuals who were also at this party, to the point where neighbors who heard this commotion came outside, and from their perspective, they thought Ms. Drummond was being beaten and attacked by this group of people. One neighbor felt the need, thought there was such danger that he went and obtained his firearm from his apartment and told the group to let her go, to let Ms. Drummond go, and which they did finally. And as she was exiting the apartment complex, her car was parked outside in the parking lot, and the victim's car was parked relatively close. It's not clear exactly how far, but the testimony was that it was close and that Ms. Drummond could have maneuvered maybe some way, either sideways, or some witnesses said she could reverse, but other witnesses said that she couldn't reverse because there was a fence back there. But the testimony.
So you're saying this evidence was important for two purposes. One was if she were convicted, there was mitigation involved, which of course is not before the jury, but you're also saying that completely apart from sentencing considerations, all of this evidence goes to her mental state at the time of the alleged crime.
Yes.
Is that what you're saying?
Exactly.
And you're saying that the prosecutor told the jury that they could not consider that because that was, quote, mitigation evidence.
And that was, the prosecutor repeatedly told the jury that such evidence was solely for the judge to consider when he imposed punishment.
Counsel, isn't there a jury instruction that tells the jurors not to consider sympathy?
Yes.
And read in context, did the prosecutor, you're saying the prosecutor made these comments saying don't consider the evidence as an element of the crime, but read in context, how do you can't construe it as talking about don't let your sympathy, because she was a victim also, or at least allegedly a victim, don't let your sympathy interfere with your determination of the evidence. And is that misconduct?
I would argue that the prosecutor, while it's true that the jury is directed not to consider sympathy or bias for any party in the case, read in context, I would argue that the prosecutor's comment went beyond that. And he didn't argue that the jury should not consider sympathy and bias. Instead, he argued that circumstances, and at one point he said that threat to Ms. Drummond, the jury shouldn't consider that. And he defined mitigation as a lot of factors that make this not so bad. But those factors that made it not so bad went to the heart of Ms. Drummond's defense, which is that she couldn't have formed the culpable mental state because under the circumstances, she wasn't acting knowingly. It might have been something less than knowingly, but it wasn't knowingly, which is the element for the criminal mischief charge.
But the prosecutor never said that.
Well, I think it was misconduct for the prosecutor to argue that the jury couldn't consider mitigation because there is no mitigation in the guilt phase of a criminal trial. There's relevant evidence for the jury to consider that goes to the charged offenses, and there's irrelevant evidence that's not admissible. And so jurors are directed to consider all relevant evidence that's presented at trial, and that includes direct and circumstantial evidence.
So you're saying it's improper for a prosecutor at the end of a case to say, now don't feel bad for the defendant. There was evidence that she was a victim here, and it might make you feel sorry for her, but you can't consider that. Those kind of comments?
I think, no, I understand. I think in the context of this closing statement and this rebuttal, especially when combined with the prosecutor's repeated reference to sentencing, which is completely irrelevant to the jury's determination of guilt or innocence, I think that moves it from beyond just don't be sympathetic to, yes, there's all these evidence that are favorable, that's favorable to the defense, but don't consider it because the law says only the judge considers that type of evidence at sentencing. And I think had the prosecutor just kept it as like, the sympathy and bias is not a factor in your consideration. But I think the fact that the prosecutor went beyond that and repeatedly argued that there's favorable evidence, but don't consider it because that's for the judge at sentencing. And I think that, in addition, kind of exacerbated this problem because, one, sentencing is not relevant to the jury's consideration, and two, invoking the judge's position and arguing that the judge would also have a say in weighing the evidence, I think was highly improper because it kind of it lessened the jury's verdict. I mean, the jury's responsibility in its verdict because it implied that the prosecutor, like the judge, would also have a say in considering the evidence, which the judge doesn't because it's the jury's province to find the facts and determine guilt. So I think in combination, the reference to mitigation, sentencing, the judge, and favorable evidence to Ms. Drummond, especially when the issue is her mental state, I think all combined, that's the misconduct.
How does the prosecutor's statement, I think he made it, or she made it a couple times, that the jury needed to do their duty, how does that factor into this?
I think that further, because when she made that, when the DA was when he made that comment, it was also combined with this, even if there's mitigation, do your duty and convict her. Well, one, juries, their duty is to consider the evidence and return a verdict based on how they view the evidence. So they don't have a duty one way or the other to convict someone. But I think read in combination, these statements were the entirety of the prosecutor's closing argument. And I think, and then combined with like the children, consider the endangered families when there's no evidence of any children or endangered families in the neighborhood who are affected by this car accident. I think combined, and then with the final statement to the jury being, do your duty and convict her, even if you think there's mitigation, even if you think, which I would read in context of the other statements as evidence favorable to her defense, I think that was highly improper and outside the scope of what the jury was required to do.
You acknowledge we are reviewing this for plain error?
Yes. But I think even under plain error, there are ethical boundaries under which the prosecutor must stay. And even prosecutors as agents of the state have a higher duty to avoid comments that mislead and prejudice the jury. And I think the prosecutor, given how repeated and glaring and flagrant the misconduct was in this case, I think it rises to the level of plain error, even without a defense objection.
Was there anything in the closing argument by the defendant that would clue the judge in that something bad is going on here?
No, there was no objection.
No, I know
by
that.
defense counsel.
But was there anything, the way the way the defense argument proceeded, that the judge would be saying, what exactly is going on here? Is this proper? Is there anything that would clue the judge into that?
I don't think so. I think defense counsel's argument centered on the fact that the prosecution didn't prove knowledge or the mental state in this case. But I think given the fact that this is a jury trial and there's no mitigation evidence that, unlike a penalty case for a capital case, I think these are pretty fundamental principles of criminal law that the defense can argue reasonable doubt, and the jury can consider it in their evaluation of the evidence. And to argue that the jury couldn't consider a lot of the evidence because it was mitigation and that was for the judge, I think that would have clued the judge in that this was improper. because sentencing alone is improper to raise during closing argument to a jury. Okay, I'd like to reserve the rest of my time for rebuttal.
Sure,
Thank
you
you.
have 2 minutes and 5 seconds remaining.
Good afternoon. Colleen Wart, attorney registration number 49965, appearing for the people. May it please the court. I plan to respond to a few of defense counsel's points on the issue of prosecutorial misconduct, and then I'd like to move to the issue of the court's answers to the jury questions during deliberations, though I will welcome any questions this court may have as far as relevance or the sufficiency of the evidence issues. First of all, as for prosecutorial misconduct, we are looking at this under a plain error standard. And some of the standards that we're using for prosecutorial misconduct are that we're taking the statements of the prosecutor, evaluated in context in light of the evidence, opening statements, and all the arguments as a whole.
Well, is it ever proper for a prosecutor to tell the jury that in order to do their duty, they must convict the defendant?
Case law tells us that it is improper to tell the jury that it is their duty to convict. Under the circumstances here, that's not what it is in context. If you look at the closing argument and rebuttal, the prosecutor had just talked about jury nullification. The prosecutor was telling the jury that they had a duty to follow the instructions as given by the court, the written instructions. And then the statement directly following, where he tells the jury to do their duty, is when I have met all of the elements, telling them that they must fairly evaluate the evidence and make a decision.
I mean, what was said is, I have it, prosecutor said, do your duty, that you took an oath to do. That is when I proved my elements beyond a reasonable doubt. Even in the face of mitigation, you have got to return a verdict of guilty. Isn't that telling the jury that they have to return a verdict of guilty?
In the context of the way the prosecutor was saying it here, when I have met my elements beyond a reasonable doubt, it was referring the jury back to the oath they took. It was referring the jury back to the written instructions as the judge had given them, telling them that with that reasonable doubt standard, when the elements were met beyond a reasonable doubt, if the elements were met beyond a reasonable doubt, then they would return a guilty verdict.
They must return a guilty verdict. Not you may, I mean, there's obviously, everyone would agree that it's perfectly appropriate for the prosecutor to say, if I prove my case beyond a reasonable doubt, you should return a verdict of guilty. The question is, can the prosecutor say, you must return a verdict of guilty?
I think that in the context of this argument, well, the word must by itself looks improper with duty. I think that you can take this phrase simply by itself and have it appear to be improper. But evaluating this in the full context, I don't think that the word must return a verdict of guilty is the way that it was intended by the prosecutor. I think that it was in response to the issues of sympathy in the case, discussing jury nullification, and pointing out to the jury that if the elements as placed in the written instructions were met, then a guilty verdict would be appropriate. Now, particularly under a plain error standard as well, if we're comparing this to other cases where, the court has found error or reversible error under that plain error standard, the statements made here are not as egregious in comparison. And the context in which, particularly the mitigation words were used, the prosecutor specifically defined how he was using the word mitigation here, things that make this case not look so bad.
But if your opponent's right, and what the prosecutor said to the jury was, do not consider this entire class of evidence that was called, I don't know why, but mitigation. that's pretty egregious, isn't it? Particularly when really the only issue here was the culpable mental state of the defendant. It's pretty egregious, isn't it?
I think that there's a few things in the argument that let us, within the closing argument, particularly the rebuttal, that let us know that that's not what the prosecutor was actually trying to say to the jury. Well, it is improper. Our case law tells us that the jury is to consider all properly admitted evidence in deliberations. Here, with the prosecutor's references to sympathy, and then talking about mitigation directly after that, saying things that make this not look so bad, and then moving into mentioning jury nullification or making a decision based on sympathy, I think that lets us know that the prosecutor was not telling the jury that it couldn't consider properly admitted relevant evidence in this case, even if it was favorable to the defendant. I think those elements tell us that that's not what the argument was meant to do, and that's probably not how the jury took that.
Does it matter does it matter what the prosecutor intended, or does it matter only what a reasonable person, a reasonable juror would take the prosecutor to mean?
It does matter what a reasonable person would take the prosecutor to mean. The courts have recognized that in the moment, in argument, things may not come out as artfully or as scripted as we may intend. And because of that, we're looking at this with a standard of looking at it in full context and looking at it with a more lenient eye to what sort of rhetorical devices or embellishments may be used if something is a fair inference, and realizing that it may not come out in the same way as it was intended or what the full message is, which is why we look at it as the full argument. Now, the record in this case also tells us that the victim pled guilty in her own third-degree assault case, and because that was part of the evidence, the prosecutor was more concerned about an issue of sympathy here and focused on it so strongly because there were aspects of this case that painted the defendant as a very sympathetic figure, a participant in this domestic violence incident leading to the incident in the parking lot with the van hitting the car. Now, the prosecutor emphasized that the jury should not make a decision based on emotion. And with this, the other aspects of mentioning the children, it's highly unlikely that, or there's no reasonable possibility that after being told by the prosecutor repeatedly not to make a decision based on emotion, that they would then go and make a decision based on emotion influenced by references to children. Coming back to the plain error standard, there's simply no reasonable possibility that these statements would have so inflamed the jury to induce them to convict on one charge, the criminal mischief charge, at the same time acquitting on third-degree assault. Now, if the court doesn't have any further questions on this issue, I'd like to move to the response to the questions asked by the jury during deliberations.
Let me ask you one follow-up question before you get there. It seems to me it would have been perfectly appropriate for the prosecutor to say that, as the jury instruction tells the jury, you should not decide this case on the basis of sympathy for the defendant because, as the prosecutor, I think, said, she had a really bad day. I think you used those words, and I think that's a fair characterization. She had a bad day. And that would be a proper basis or you shouldn't consider that she had a bad day if she later committed a crime. But what troubles me is that the way the prosecutor argued this, the prosecutor did say, as your opponent is arguing, don't consider this evidence for any purpose, this mitigation evidence, when it seems pretty obvious that, quote, mitigation evidence was at least relevant to a determination of the defendant's mental state. How How do you distinguish that? I mean, do you think the prosecutor only said, don't consider it for this purpose, but you may consider it for the other purpose? Or do you think the prosecutor really did say, you can't consider it for any purpose?
I think that the prosecutor was only referring to the elements that painted the defendant as a sympathetic figure here. I don't think that the prosecutor was telling the jury that they couldn't consider aspects which may go to the mental state of knowingly, which is what was required for the criminal mischief. This is, the mental state required for that was not intentionally. So it's a lower standard. And the jury also did acquit on the charge that even required a lower mental state, the recklessly or knowingly for the third-degree assault. But with the context of the use of mitigation, telling the jury how he was using that word mitigation, I believe that was only going to sympathetic aspects that wouldn't necessarily have to do with the actual sequence of events that could have affected whether or not when she climbed in that vehicle with the keys and she pushed on the gas, she knew that the van was going to hit the car.
But if she was so distraught, based upon the events that fairly immediately preceded that, isn't that at least relevant as to her culpable mental state when she puts her foot on the gas?
But her reactions and the mental state that she would have had going through those events is different than the actual events that were going on that would make the jury feel sympathetic towards her. Say, being part of that mutual fight, you know, them trying to keep her from driving and taking the keys from her, things like that. Those are the things that would lead the jury to be sympathetic. That's different than the defendant's actual reaction to that sequence of events, which may have affected her mental state.
Let's say, for example, that as a result of being beaten up, she was in shock, and that led to her driving the way she did. In that context, wouldn't those circumstances be relevant, the mitigating circumstances as they were described? Again, going to what her state of mind was at the time of the crash.
Sure. With that sequence of events and looking at the way that the closing argument was being argued again with this, and the emphasis on the sympathetic elements of it, jury nullification, there's telling the jury that there was no element of that was telling the jury that they couldn't consider that sequence of events or her reaction to it as it would apply to her mental state. It's referring to the elements of sympathy within that circumstance. And the record has inconsistent evidence as to exactly what happened in that sequence of events or what exactly the defendant's demeanor behavior was getting into the vehicle. And it would be the jury's job to resolve those inconsistencies. And with the sympathetic elements coming closely in line with that, that's why the prosecutor focused so much on the sympathy and bias aspect, especially in the rebuttal close, to encourage the jury to consider evidence for its appropriate purpose under the elements, but to stay away from sympathy and jury nullification. Now, just briefly, if there's no further questions on the issue of prosecutorial misconduct, I would like to touch on the response to the question that the jurors asked during deliberations. And the standard of review on this issue was for abuse of discretion and plain error. And there were 3 questions asked by the jurors. They did involve the mental states required for both offenses. And while defendant only challenges the answer that was given to one of these, the dictionary definition of accidentally, all three taken in their entirety did show the jury's confusion regarding those mental states. Now, the case of People v. Leonardo is very instructive on this issue. The question asked was very similar, a new term, and the jury confusion on whether or not that was encompassed by the mental state. And here the judge appropriately and unambiguously directed the jury back to the written instructions and the mental state required, and then provided them with a dictionary definition so that they could decide for themselves whether it was encompassed within the jury instruction and distinguish it.
Thank you. Your
Thank
time
you.
is up.
Briefly, the Attorney General makes much of the jury's acquittal on the assault count, but the evidence for that was significantly weaker at trial. There was almost I believe only the victim testified that Ms. Drummond struck her, but another eyewitness there said no, it was the victim that struck Ms. Drummond. So I think the acquittal on that count doesn't prove that there was no prejudice from the prosecutor's statements. With regard to the jury instruction, just briefly, even under Leonardo, the instruction was erroneous because basically the court in Leonardo, in that case, the jury had asked about suspicion and whether it satisfied the knowing or believing element at issue in that case. And the judge in that case didn't elaborate, and the Supreme Court found that was error. And the Supreme Court said that in instances where there's certain instances where the trial court must elaborate. And, but one situation where it's not necessary is where the question calls for an opinion that, about factual matters that the jury alone could resolve. And I would argue that in this case, the jury asked if it was accidental. If it was accidental, is that willful knowingly? One, this question calls for an opinion about a factual matter that was for the jury to decide. The entire case came down to the defense of whether it was accidental or knowingly, as the prosecutor alleged. The defense theory was that Ms. Drummond's conduct fell below, accidentally meant Ms. Drummond's conduct fell below the knowingly mental state. And below knowingly, it could have been a lesser mental state. But the jury's instruction confined that accidental to a very specific definition. And so the jury was presented with this false dichotomy, either knowingly as defined by the statute or this very limited circumstance as defined in the court's instruction. I see I'm out of time, so I would ask this court to reverse. Thank you.
Thank you, counsel, for your excellent arguments. The case is submitted. We will issue a written opinion as soon as we can. Counselor excused in this case after you vacated the table. Other counsel, please. Whenever you're ready. No problem.
Good afternoon. I'd like to reserve 2 minutes for any necessary rebuttal. My name is Kendra Garska, attorney registration number 51050, and I represent respondent appellants in this matter, Old Dominion Freight Line and New Hampshire Insurance Company. May it please the court. On December 30th, 2006, claimant Daniel Sanchez was involved in a significant motor vehicle accident. Respondents do not dispute the underlying work accident. Immediately following the motor vehicle accident, claimant's injuries were appropriately treated. However, several months, a year and a half after this motor vehicle accident, claimant began alleging that he was sustaining seizures and turned this case into psychological issues, and it is now being psychologically driven. As you saw in our brief, claimant has a long pre-existing history of psychological issues that he failed to disclose to his treating physicians and failed to disclose during discovery. He only acknowledged his history of psychological issues when he was confronted with evidence of the same. Specifically, we are referring to claimant's termination from the New Mexico State Patrol in the early 1990s when he was found to be not mentally fit to carry out the duties of a police officer.
But all this was before the ALJ, wasn't it?
Correct, it was.
And at least implicitly, the ALJ rejected your position.
Correct. So we can move on from the fact, that argument. The main issue that we would like to argue before the court today is that ALJ Lamphier's finding that claimant overcame Dr. Fall's division IME by clear and convincing evidence was incorrect. Clear and convincing evidence is evidence that is unmistakable and free from serious or substantial doubt. The mere difference of medical opinion does not constitute clear and convincing evidence and is not enough to overcome a division IME. Dr. Fall performed the second division IME in this matter, which is the division IME at issue, in September of 2016. She opined that claimant had reached maximum medical improvement in July of 2011 and found that he was only entitled to an impairment rating for his cervical spine of 12%. She opined that claimant's pseudo-seizures and possible conversion disorder were not work-related. And she pointed to the lack of objective findings for a traumatic brain injury and noted claimant's pre-existing anxiety and depression. Dr. Fall's opinions are supported by several physicians in whole or in part. First, Dr. Woodcock. He is a neurologist at the University of Colorado Anschutz Medical Campus, and he was referred by a treating physician, so would be considered a treating physician. He opined that claimant's psychiatric findings were driving his physical symptoms. He opined claimant had pseudo-seizures, not actual seizures. And then when Dr. Woodcock's evaluation was given to claimant's treating physicians, Dr. Higginbotham specifically, Dr. Higginbotham rejected them as absurd because he didn't agree with them. Claimant was also evaluated by Dr. Phillips, who is the medical director for CNI Epilepsy Center. Dr. Phillips reviewed all 7 EEGs and found there was no abnormal features or epileptic activity. Claimant was evaluated by Dr. Henry Roth, who is a board-certified medical examiner and board-certified by the American Board of Internal Medicine. He stressed claimant's pre-existing psychological issues and noted no organized pathology related to seizure disorder, and again, said there were non-epileptic seizures.
Let me ask you something. If the ALJ concludes that the DIME opinion has no probative value, is that something we can overturn?
We are arguing that he incorrectly concluded that the DIME had no probative value because there is clear and convincing evidence that the DIME's opinion is supported by 6 physicians, either in whole or in part, and the standard for clear and convincing evidence is that you are free from serious doubt.
But
And
isn't that a call that needs to be made by the ALJ, resolving determination, issues of credibility, for example?
I don't believe clear and convincing evidence is a credibility determination. A credibility determination would be claimant's presentation, claimant's state of mind.
But it's not the number of witnesses, I take it.
Correct.
I mean, the ALJ basically said, I don't think Dr. Fall knows what she's talking about. I mean, in the vernacular, that's kind of what he said. Isn't that something within the sole authority of the ALJ to decide, not our authority?
We are not asking you to reverse the actual finding, but to send it back and show that the ALJ did not properly apply the clear and convincing evidence standard, because there is a plethora of evidence that we presented that supports Dr. Fall's opinions.
But if the ALJ found, as I think he did, that the dime physician really didn't know what she was talking about, I mean, she was spouting nonsense, regardless of whether other doctors either agreed or disagree with Dr. Fall, once the ALJ makes that determination, there really is no dime with any probative value at all, is there?
If the ALJ does not agree with the dime opinions, then we are arguing that the clear and convincing evidence standard, it would seemingly be meaningless, because because there are several physicians in this matter who agree with Dr. Fall and who support her opinions and her findings. And if we go to the definition of clear and convincing, which includes that a mere difference of medical opinion is not enough to overcome a division IME, the treating physicians, Dr. Strom, Dr. Higginbotham, and Dr. Ricci, I'm sorry if I'm mispronouncing that, presented a difference of medical opinion from Dr. Fall and Dr. Woodcock and Dr. Thwaites and Dr. Roth. And so merely just having that difference of medical opinion is not enough to overcome the division IME, is our point. And claimant was also evaluated by Dr. Thwaites, who is a licensed neuropsychologist, and he stated that claimant's presentation was inconsistent, and his tremor was not associated with actual symptomology. He found claimant's presentation to be dramatic, and claimant was also evaluated by Dr. Moe, who is also board certified. And Dr. Moe also found that claimant's presentation lacked authenticity and was a way an unsophisticated individual would simulate dementia. And he believed that claimant was behaving this way because he thought it would be beneficial to him, and found that there was a lack of objective findings to support claimant's subjective complaints. And finally, claimant was also evaluated by Dr. Goldman, who indicated that claimant's psychiatric factors should be explored, which were not work-related, which included schizophrenia, multiple personality disorder, and manic depressive disorder. And we are aware that claimant was previously diagnosed with depression. These 6 physicians support Dr. Fall's opinions, and the opinions from claimant's treating physicians represent a mere difference in medical opinion. The standard, as I stated, of clear and convincing evidence would be meaningless if we allow 6 doctors who agree with the division IME and allow the ALJ to merely toss all of that aside and say, no, I think that these other doctors have the correct opinion.
Excuse me, but doesn't the case law indicate that the issue of whether a party has overcome the DIME's opinion is a question of fact to be resolved by the ALJ?
I don't believe it's a question of fact when we're discussing the standard of clear and convincing evidence, and that we believe there is substantial evidence in the record to show that he did not properly apply the clear and convincing standard.
So let me give you a hypothetical. Suppose the dime physician is completely incompetent. I mean, has no business rendering the opinions that he or she did render, didn't have the expertise to render those opinions, and the ALJ recognized that and gave no probative, no value at all to the dime opinion. You're saying that the ALJ still, under those circumstances, has to treat the dime in a way that if other doctors come in on behalf of the claimant and say, no, that's wrong, that's just a mere difference in opinion and doesn't rise to the level of overcoming the dime. Is that your argument?
We're saying that the ALJ has to give should give deference to the dime as outlined in the statute, and that the statute clearly indicates that there needs to be more than just a mere difference of medical opinion. If it's so egregious, presumably, then all of the physicians would line up against the dime, and it would be fairly obvious. But in this case, we do not think it's obvious. We think there's enough dispute in the medical records and enough dispute in the opinions of the treating and independent medical examination physicians that it created a difference of medical opinion. And it should not have been overcome by clear and convincing evidence. And if we follow that Dr. Fall's opinions were not overcome by clear and convincing evidence, it then must be found that claimant is not permanently and totally disabled. Both the vocational rehabilitation experts in this matter indicated that it depended whose medical opinion was believed. If Dr. Fall found there was no work restrictions, and they would agree that claimant would be capable of returning to work. And we would also ask that no additional medical benefits be awarded. And finally, a claimant requested attorney's fees in his brief, and we would argue that this appeal is not frivolous. We believe there is a genuine question of whether the ALJ correctly applied the clear and convincing standard, and so fees should not be awarded. So we ask that you would send it back to the ALJ to determine the correct, clear and convincing evidence standard that Dr. Fall's opinion was not overcome. If there are no more questions, I will reserve my time.
Thank you. You have 2 minutes and 42 seconds remaining.
Good afternoon, Your Honors. My name is David Webster, attorney registration number 28113, and I represent the claimant Daniel Sanchez, also the appellee in this case. First, it should be noted that respondents are not indicated that they have any disagreement with the law on this claim or the standard of review for you. Their appeal is based entirely upon a dispute with the administrative law judge's factual findings. As a result, they are requesting this court to reevaluate the evidence that was produced in this case and substitute its own judgment for that of the administrative law judge. Under these circumstances, I think the best place to begin is the standard of review for you. It's well established that a reviewing court must uphold the findings of an administrative law judge as there is substantial evidence to support those findings. In doing so, the reviewing court has to view the evidence in the light most favorable to the prevailing party, and that would be the claimant appellee in this case. You have to defer to the administrative law judge's resolution of conflicts in the evidence. You have to defer to his determinations of plausible inferences drawn from the evidence. The administrative law judge can believe all, part, or none of a witness's testimony, and that includes the experts. Where evidence is in conflict.
Is the dime different? I mean, I think the respondent is arguing that somehow the status of the dime opinion is different than every other doctor who offers opinions. Is that true?
The dime opinion is the only way to overcome a dime is by clear and convincing evidence. But my point would be that when we get to this stage, it's irrelevant. It doesn't factor into your determinations as far as whether to affirm the judge's decision or not. In this particular situation, where the evidence is conflicting and where the ALJ makes determinations, you're supposed to follow those determinations, and conflicts are decided based upon what the ALJ determined. That includes where a different factual determination could have been reached. And the only question for you is whether the inferences drawn by the ALJ are plausible. Now, in this case, I think we need to begin with the following conclusions, which are, this judge utilized the proper standards in making his determinations. He utilized the clear and convincing evidence standard with regard to the dime, and he utilized the preponderance of the evidence standards for maintenance medical benefits and for permanent total disability. He made detailed factual findings which were supported by the evidence. His findings comprised a total of 26 pages. He had 84 paragraphs summarizing the facts in this case. He took into consideration the totality of the record before him before making his decision. Specifically, he credited the opinions of Dr. Higginbotham, Dr. Strom, Dr. Mann, and Dr. Ritchie with regard to the severity of claimant's injuries. In that regard, the appellate court is required to credit those opinions as well. Dr. Higginbotham has treated claimant on more than 120 occasions, as found by the administrative law judge. He's witnessed multiple incidents of seizures, and those seizures have ranged from absent seizures, where he's gone for just a few moments, to full tonic-clonic seizures, where he is completely unresponsive. Dr. Ritchie has treated claimant on over 240 occasions, and at the time of hearing, and he's also witnessed multiple seizures himself. Dr. Strom is a professor of neurology at the University of Colorado and specializes in epilepsy. Her involvement in this claim brought in a whole team of doctors from the University of Colorado. It brought in Dr. Kluger because Dr. Strom was unable to recognize a certain movement that the claimant was evidencing. So she brought in Dr. Kluger, who is a movement disorder specialist, and he immediately recognized Holmes tremor, started treating it with Cinemet, and was successful in that treatment. She brought in Dr. Tsai, who is a sleep disorder specialist, who recognized that claimant's sleep disorder was directly tied to the traumatic brain injury. Her coming into this case also brought in the facilities with the University of Colorado, which are state-of-the-art, and a whole team of physicians that are able to work on one individual. To top it all off, they're the teachers. They're the ones that teach our doctors. The ALJ credited the opinions of Mr. Fitzgibbons, who was the vocational assessor in this case, to conclude that claimant was permanently totally disabled. His opinion was based upon meeting and testing the claimant, as well as reviewing the medical records. And I'd note that their own vocational expert even relied on his testing and did not complete testing of her own. That says a lot about how his reputation is among his own peers. Based upon my review of the records, there are at least 28 different physicians who have treated this man and have at different points in his recovery.
But the dime has some special significance in the law, and the question is kind of the same question I asked your opponent. Is the ALJ free to just conclude, as I think he did, that this doctor's opinion is pretty much valueless?
Now, I think if you were, I think if he was taking the position of this doctor did everything she was supposed to do, this doctor did a thorough review of everything, and this doctor made her determinations, yes, I think it would be very difficult to overcome, but that didn't happen in this case. This doctor spent 5 hours reviewing and writing a report, 2,000 pages of records that she says she went through. And when everything was said and done, what it really came down to was that she merely did and the ALJ found this, she did a brief review of the records, and she couldn't even tell us what percentage of the records she actually reviewed. When you read her testimony, it becomes pretty clear she didn't read the records. She didn't know doctors that had treated him. She didn't know what the process had been throughout the whole treatment process. She was unfamiliar with the standards that epileptologists look for as far as identifying epilepsy. She didn't understand seizures. And the reality is she took basically 2 IMEs, one from the division IME, Dr. Jacobs, that was done back in 2010, I think it was, and the other from Dr. Roth. And if you look at Dr. Roth's deposition, it became absolutely clear that he did a seriously truncated medical records review. He never met with the claimant. And he did an incredibly poor job at reviewing everything. He didn't review years' worth of records from, I believe, 2012 to 2014, and only a smattering of records from 2014 to 2016. And this was what she was relying on. And what the ALJ recognized was that she simply had not done her job. She simply hadn't even tried. I mean, her bias was shown at one point in time where she said, "We know what's going on here." Well, who was we? And what she was referring to was the IMEs, because that was where her primary reliance was. In fact, the ALJ specifically found the opinions of Dr. Fall, Dr. Moe, Dr. Roth, Dr. Phillips, and Dr. Thwaites unconvincing and unpersuasive when considering the totality of the record. Thus, the court must also presume their opinions to be unpersuasive and unconvincing. And the ALJ's conclusions make sense when one reviews the opinions of all these respondents' experts in conjunction with the medical records of the case. It becomes very clear that the dime was relying heavily upon those IMEs and not paying attention to what was in the records. As noted by Dr. Higginbotham, who did a record review of all of the providers that had actually treated Mr. Sanchez, he noted that not one of them opined that the claimant was malingering, feigning, or that he had a factitious presentation. Additionally, respondents didn't even bother to update several of the experts' reports that had been submitted back in 2011. And those were Dr. Thwaites, Dr. Moe, Dr. Phillips, and Dr. Goldman. Nor did they have several of these same experts testify. Dr. Thwaites, Dr. Phillips, and Dr. Goldman did not testify at this hearing. When Dr. Moe did testify, he ended up defeating his own diagnosis of factitious disorder. And he did that when he noted that if a person is having seizures when they're sleeping, factitious disorder is not in play. And what we know from the evidence is that nurses that were watching Mr. Sanchez on a regular basis, 24 hours, 7 days a week, were noting that he was having seizures, pretty significant seizures when he was sleeping, so much so that there were periods of time that he actually defecated as well. Now, while respondents recognize the correct legal standard, and I've kind of talked about this, the administrative law judge has broad discretion in determining whether the claimant has met his burden of proof. And on review, burden of proof is irrelevant no matter how high that burden of proof is. With regard to Dr. Fall, I think you had mentioned her specifically. The ALJ's decision to disregard her opinions was very much justified by the record. She agreed on cross-examination that she should be fair, impartial, unbiased, and thorough. She only read about 5 hours worth of records and couldn't say what percentage of those records she read. She relied primarily upon Dr. Roth and Dr. Jacobs instead of reading the medical records herself. And she didn't disagree that she had relied heavily upon respondents' own experts. She was unaware that Dr. Roth, Dr. Phillips, and Dr. Thwaites were not even treating physicians. She did not know that Dr. Ritchie was a treater. She did not know that he had witnessed seizures. She did not know the severity of the seizures that he had witnessed. She concluded there was no movement disorder, and thus she didn't review the records of the movement disorder specialist, Dr. Kluger, because she was disregarding that diagnosis. She didn't know Dr. Tsai determined that the sleep disorder was related to the traumatic brain injury. She didn't know Dr. Higginbotham had witnessed seizures on multiple occasions. And she didn't recall reviewing Dr. Rosenbaum's cardiology records. And she minimized his determination of syncope by saying, it's just fainting. She didn't know that seizures are one of the causes of syncope. She didn't know Dr. Walsh had determined that neurogenic bladder was caused by the traumatic brain injury. She wasn't aware that Dr. Seaman, a dentist, had opined that all dental treatment was due to the work injury. She did not know that Dr. Salcetti had witnessed seizures following dental surgery, and she was unaware that those seizures were observed for 2 hours. She didn't know he fractured teeth during seizures. She was not aware that Dr. Shah had opined that his balance issues resulted from the work injury. She did not know that Dr. Shah had opined that he would have tinnitus for the remainder of his life because there was no cure. She did not know he needed hearing aids or a neuromonic device. She did not rate him for tinnitus, but she agreed that the rating guidelines expressed that 3 to 5% should be given towards tinnitus. She tried to say that the tinnitus was pre-existing, yet she couldn't point to any record where she got that information. She didn't know where she got that information at all. She didn't know what the epileptologists look for in the EEG findings, and she didn't know that the EEG findings from 2 tests were consistent with epileptic findings. She didn't know that Dr. Roth had only reviewed records of respondent independent medical examiners up to 2012. She wasn't aware he didn't review records from 2012 to 2014. She wasn't aware he had not reviewed a majority of the records between 2014 and 2016. She didn't even know that he had worked for respondents without incident for over a year. And she did agree that no records were ever provided to her that indicated that the employer ever expressed concern about Mr. Sanchez's mental functioning. Thus, in this regard, when the totality of the record is taken into account, our position is that the administrative law judge was absolutely correct. He had an abundance of evidence. This wasn't just substantial evidence. This was pretty overwhelming evidence of Mr. Sanchez's condition. Are there any questions so far? Then I think I'd like to address attorney's fees real briefly. This is not a case where the respondents are trying to create some kind of a novel legal argument. They're not trying to change the law in any fashion. They're just trying to say that their interpretation of the facts should be what are imposed here. And there's no prohibition upon respondents acting zealously when they're doing this, but it's different to act zealously as opposed to but instead of preventing facts as contained in the records, they chose instead to misinterpret and simply misrepresent evidence presented in the case in an attempt to bolster their own position. This is frivolous as argued. Examples. They state that claimant failed to disclose that he had any psychological or PTSD diagnosis to his providers, which caused them to reach incorrect conclusions. This is simply untrue. Claimant disclosed from the very beginning that he was being treated for depression, and that can be found in multiple exhibits that were produced by claimants. And if the court would like, I can give you citations to the particular portions of the record for any of the things that I'm bringing up here. Dr. Ritchie, in his first meeting with claimant, diagnosed PTSD, and he diagnosed PTSD with chronic and acute rekindling exacerbations. Now, when he said rekindling, what he meant was that this was a pre-existing condition, and that PTSD, as he testified, doesn't actually resolve what. I'm done.
Yes, thank you very much. You have 2 minutes and 42 seconds.
I don't think we have any further arguments to rebut.
You have no rebuttal?
Not, I'm going to waive my rebuttal.
Okay, thank you. The case then is submitted. Thank you, counsel, for your arguments. We will issue a written decision as soon as we can. That completes our docket for this afternoon. So the court will be in recess, and the bailiff will please announce the recess.